Section 86.1, going back to that, is your anti-hacking provision. In other words, anyone who unlawfully hacks, accesses an information system, and please, the word information system must now be read in a big context, such as the word computer, as you will see in the cybercrime bill. Any computer, any handheld device, any of these fancy phones that you carry. I don't have one for obvious reasons, security. All right. Section 86.2, anyone who intentionally and without authority interferes with data. Remember what I said, the people who deface your website, that come there and destroy information on your information system. 86.3, the anti-cracking provision or anti-thwarting. In other words, where there is a password provision or there's a password protector and you use a device or a software to overcome same, then you are guilty of an offense. And 86.4, the locked DVD. Can everyone see the locked DVD? All right. Have you ever gone to the DVD store, watched your movie on the DVD, liked the movie, then plugged it into your laptop, and for some reason it doesn't read the CD? Right? It's because on the inside of the table of contents, there's been a digital lock that has been placed there. The moment it spins up on your computer, there's something that says, if this is not a DVD player, you cannot read me. But we are obviously all living in the new age of technology. We all know Google. We all know DVD rip. Let's not say what we all do in our spare time. Okay? So there are softwares that can overcome this copyright protection. But every time when you overcome this copyright protection, you are actually committing a criminal offense. Then we have your denial of service attack. All right? This is, like I said, where you intentionally go out of your way to make sure that my system doesn't work. And there's many ways of doing that. I can dump malware or a worm on your computer with a memory stick. I can send you an email where a worm is disguised as in an attachment. I always tell people, if you receive an email from a recipient that you've never met, that you've never spoken to, and the email is for some strange reason very short and not specifically addressing anything, then it's not your email. And in most probability, it is a trap. And hence, I'm going to re-emphasize the fact of education and vigilance. Okay? It's all nice for us to come and sit here for a couple of hours and to chat about this. What do you do about the information that you take here from? Do you go home to your spouses and share it with them? Do you sit your kids down and tell them not to maybe use WhatsApp or not to use whatever WeChat because it has a propensity of exposing, should I say, sexual predators of kids? Do we do that? We probably don't, because the moment we leave our workspaces, we say, yeah, that's the work stuff. But what we forget is that all of us can be victims of cybercrime. Then we have also the anti-spamming provision. I must say, however, this has now been repealed by the Consumer Protection Act. The provision here used to say you must opt in order to, the other way around, sorry. You must opt out of a unsolicited communication. In other words, in terms of this provision, as I said, which has now been repealed by the Consumer Protection Act, I can bombard you with spam, as much spam as I like. But the moment you send me a mail and you say, please take me off your list, okay, you are opting out. And to opt in is where, yes, when you came here, there was a form, there was a registration form, right? At the bottom of that registration form, it said, do you want to get promotional material from the organizers of this conference? You were opting in, just for your information, okay? So if the organizers happen to bombard you with material, it's not spam, okay? You've agreed to it, all right? So that is the opting in and the opting out and the whole story with spam. Then once again, e-fraud, e-forgery, e-extortion, nothing else but extortion, fraud, and forgery. The admissibility and evidential weight of electronic evidence. All right? I was talking to attorneys yesterday. I was at practice management conference for attorneys at the Bytes Conference Center yesterday. And I was so amazed about how my own colleagues don't know what Section 15 says of the ECT. All right? And our locus classicus case in interpreting Section 15 is nothing else but the matter of State versus Mutata. In Mutata, the whole issue was that video, which the gentleman had taken on his phone, which was copied onto the computer, then copied from the computer to a memory stick, and from a memory stick copied onto a CD. The big issue there was, should this evidence be admissible? And unfortunately, the counsel, and senior counsel, by the way, but I won't mention his name, he just got it wrong on that one. He went and argued, no, because of this chain of custody and you cannot use this evidence, it's inadmissible and so forth. I want us to get this out of our systems today. I never ever want to hear you speak incorrectly about this again, all right? Every electronic evidence is admissible, full stop. In a 80-page judgment, which I'm going to summarize in 1 minute now, basically said the following. Said, number one, electronic communications are valid. Section 11, Section 12, Section 13, electronic writing, electronic messaging, electronic signatures, they are all valid. And if you send an electronic message to someone, you should expect that that particular person may reply with an electronic message. In other words, if you set the pace for a particular platform of communication, expect that maybe that particular offer will receive a response on that particular platform. That's what she said in 80 pages. And the other legal rule that was said in there was that we have a reception rule. Okay? When is the email deemed to have been received? And I'd like you to please remember this. It says the email is deemed to be received once it enters an information system of the recipient and, not or, and must be readily accessible. In other words, I got a question yesterday. So what happens if I don't open my email? In other words, I see an email, I say, oh no, I'm not opening that email. Okay? And I leave it. And 2 weeks go past, and there was some contractual thing that was being discussed in there. I cannot come back and say I didn't see that email because it was on my information system and it was readily accessible at the time. It was there. I didn't open it, but it was there. So that is the reception rule, that little added value that I'm giving you today.